a tremendous resource in our firm, a former administrator with the Department of Labor, and she was actually one of the individuals who was leading the charge in implementing the 2004 rules that were implemented. So the last time that the DOL went through a big change with the rules. So we really have a tremendous resource in her experience with the DOL and implementing these type of issues. Really, at Mendelson right now, we are really at the forefront of assisting employers in implementing the changes that are necessary to get into compliance with the rules and implementing those changes in a way that really fits with an employer's business objective. So I want to go ahead and jump into the topic today. For those of you who joined us last time, we went through an overview of the new rule. Some of the information that you see today will be similar to what we talked about last time, but my intention today is to go through in more detail information about the reclassification process and some of the considerations that employers should be looking at when implementing a reclassification of an employee from an exempt position to a non-exempt position in light of the new rule. So this is our agenda for the day. First is talking about how to pay reclassified employees, how to calculate overtime for reclassified employees, and what policies your organization needs and really should be aware of, and maybe fine-tune those policies and practices in anticipation of reclassifying certain employees. So just briefly, most of you by now probably know what the final rule was. The final rule increases the minimum salary level to $47,476 on an annual basis, $913 a week. Another aspect of the final rule is that employers can use up to 10% of the salary level can be accounted for in non-discretionary bonuses, incentive payments, and commissions. Essentially how this works is that if an employer was going to use this type of credit for incentive pay, that they would need to make sure that the exempt employee was paid the minimum salary level of at least 90%, or at least 90% of the minimum salary level, and then the bonus would make up the additional 10% to get them to the minimum salary level of $47,476. I'm interestingly enough, I'm in an internal training about the regulations right now for our law firm, and one of the things that we've discussed that, this is implementing these type of changes. If you as an organization intend to try to take advantage of this credit in terms of incentive pay for meeting the minimum salary level, there's some tricky issues that are associated with it, and we really recommend that you do consult counsel in implementing those changes, because there's a few nuances that are important for employers to be wary of when they're implementing those type of changes. The other change is that the highly compensated employee level has went up to $134,004. So that's the 90th percentile of full-time salaried workers in the United States. The final rule also contemplates that there'll be automatic salary level increases every 3 years. So the next increase will be effective January 1, 2020. And as everybody probably knows, the effective date for the implementation of the final rule is December 1st. That means employers have until December 1st to make decisions on whether employees do not meet the minimum salary threshold right now, if they're being upgraded to them, whether the employer is going to raise this individual salary up to meet the minimum salary level, or if they're going to reclassify them as non-exempt and begin paying them on an hourly basis. So this is the meat of what I want to spend time talking with everyone about today, the reclassification process. So this is a process that can really take some time from the employer perspective. So we are recommending to our clients right now and employers to make sure that they start this process early. So we're going to walk through the considerations and what we recommend in terms of the reclassification process. So at the end of the day, we don't believe that the final rules are going away. The changes are going to happen, which means employers do have to get themselves into compliance by December 1st. The decision of looking at your workforce and determining if you're going to reclassify certain employees, it can take some time, especially because there's a lot of different considerations in play. Oftentimes we say that these decisions can take up to 6 months. Obviously, we're already into July, and the final rule is effective December 1, so there are not 6 months left. But right now is a good time for all employers to start working on implementing these changes if that's what they want to do. And another point to be aware of is that some state laws require prior notice to an employee if you change their pay. So that's a very important point. I know here in Missouri, there is a 30-day notification required if you're going to reduce the employee's pay. So if the net effect of reclassifying an employee may mean that their pay is reduced, it's important that you give that notice to them that's required under state law. So we recommend a step-by-step process for compliance. The first step is to identify the employees that you want to reclassify. Those employees, again, who are classified as exempt and under the new, what the new salary level will be. The second step is to implement or decide how you're going to pay the reclassified employees. There are some choices in terms of how employers can pay non-exempt workers. It doesn't have to be a strict hourly basis, and we're going to talk about some of those choices. But obviously, anybody who's implemented a compensation plan redesign, sometimes those decisions and those implementations can take some time. So we recommend getting started on those. Third, which is very important, is to review your wage and hour policies and processes. A lot of the employees, if they are being reclassified, these are employees who are exempt and who probably have not maybe ever punched a time clock or who have not punched a time clock in a long time. So there are a lot of issues associated with timekeeping policies, but also having the employee understand what is considered to be working time and what time they actually need to be recording. The fourth step is communicating the changes. This would be communicating the changes to the affected employees, as well as communicating the changes throughout the organization. And finally, an important step is to train the reclassified employees and their managers. As much as the reclassified employees will need training with respect to timekeeping policies and practices, their managers also will too. If they've been supervising these employees for a while, they're used to start supervising employees who don't punch time clock. So, for them to send an email at 8 o'clock in the evening and expect an immediate response, that's something that they're used to. That may be a practice that the manager needs to be counseled not to continue to do, because the employee, if they respond to an email at that time of the day, they're going to have to record that time as working time if they're considered to be non-exempt. So really the big decision point in terms of reclassification, getting to what you want to do with the employees that are affected by the changes is figuring out if you do want to reclassify them or if you just want to up their salary. So the first part is to identify the employees that fall below the salary threshold. So anybody who falls below the $47,476 annual salary threshold, you should pull all of their data. And also anybody who falls below the amount including compensation, bonuses, and commissions. So we recommend taking and including the incentive pay when you're pulling that information as well. So getting a really complete list in your organization of those employees that are, are in this range. The next part is thinking about what it would cost to give the employee a salary increase versus just beginning to pay them over time. Really, it's probably best to go ahead and pull all pay data for any employees that are below, probably around 50,000. That's probably an easy threshold. And I think that the idea, we've touched a little bit about incentive pay, and thinking about what to do with incentive pay is an important aspect of this decision. Many organizations offer incentive pay, and they have really strong reasons for doing so. They want to reward employees to do a good job, for the organization within a given year. If it's commission, they want to reward that person for bringing sales into the company. There are very strong organizational reasons and business reasons why employers like to provide their employees with incentive pay. So an employer really needs to look at, what are those reasons, and do we want to continue paying this individual, even if we reclassify them? Do we want to pay them incentive pay as well? One thing that employers can consider is taking advantage of the credit with respect to incentive pay. So considering that not increasing the salary level to the complete new threshold, but using a remix, knowing that you can include incentive pay to offset the cost of the new salary increase. Finally, would be to look at what the cost of the overtime would be. How many hours are these exempt employees really working? If the organization had to pay these individuals overtime for all the hours that they worked, what would be the cost to the organization of doing so? Making this decision is not, and making this calculation is not as easy as it sounds. The problem is that these employees are classified as exempt right now, which means most likely your organization does not require that they punch a time clock or really record their time in any way. So employers really have to conduct some fact-finding on this issue and find out how many hours is this employee really working per week, and will that change? Is it seasonal? Is there a period of time where we expect that the employee will be working 55 hours a week? Or is there a period of time where we expect that they'll only be working 40 hours a week? And trying to kind of flesh out that information. In terms of getting that information, we recommend you can talk to the employee's manager. Many of these employees who are, I guess for lack of a better term, kind of stay on the bubble, that they know that their salary is under the threshold, and they know that the changes to the regulations have happened. So many employees, this is a well-publicized rule. Many employees may know the changes is on the way. So, it may be helpful just to ask the employees themselves about this information and see what you can get from them in terms of certainty about how many hours you would expect them to be working, and then correspondingly what the cost would be of paying them overtime if you reclassify them as non-exempt. If you decide to reclassify an employee, there is a way to eliminate or reduce additional costs even when the employee is going to become eligible for overtime. The formula for determining what a cost-neutral hourly rate for the employee would be is on the slide. So basically what you do is you divide an employee's weekly salary by the 40 straight time hours plus the total of the overtime hours the employee is expected to work times 1.5, and that's because for each overtime hour worked, you pay 1.5 hours. We do know that this formula is legal. Tammy McCutcheon is our former administrator with the DOL, who is now a Littler lawyer, and she and the DOL provided this formula to us and the preamble to the 2003 Notice of Proposed Rulemaking. So we know that the DOL has signed off on this formula and said that it is legal. So this is a way for employers, if you're reclassifying an employee, to take a look and see what should that new hourly rate be, and calculating that hourly rate in a way that it can eliminate or reduce the additional cost that would be on the employer. Now, the difficult part in this is there's a little bit of the notion of garbage in, garbage out. This formula and being able to come to a cost-neutral hourly rate really depends on the information that you put in it. Obviously, weekly salary, that's a fixed amount. The big question is, though, the number of overtime hours that this individual will be getting paid. And again, that's something that hopefully, you as an organization can find out through fact-finding, but there is still going to be some uncertainty with that. So employers will have to make a decision. Do you want to be more conservative, so should you estimate that the person may be having more overtime hours than what you think in order so you can have a cost-neutral hourly rate. So ComplianceHR is an organization that is affiliated with Wilbur Mendelson, and we actually provide an application to calculate this cost-neutral hourly rate. And I just played with it in preparation for this presentation, and it's pretty cool. It's a pretty neat way to look at what would be a cost-neutral hourly rate. So what you do is you answer a few questions, including the employee's annual salary, any bonuses or incentive pay that the employee receives, and the number of hours worked, including the expected number of overtime hours. So, and then it also asks you a question whether you want to convert any of the incentive pay that the employee is currently receiving, if you want to convert that to salary, so it can get the employee up to the minimum salary threshold. So you input all this information, and then in one click you get the cost of the salary increase for the employee, the cost of paying overtime for the employee, and a cost-neutral hourly rate for the employee. The great thing is this is a free application you can get to through the ComplianceHR website, and it's really slick. It's really cool that you can kind of look at this and have it done in a way that complies with the law, and you know that it does. And this is just one tool that an employer can use to figure out these decisions. Obviously, it's a tool, and there are other considerations that are part of the analysis in terms of, do we want to reclassify this employee? But having this information is good for human resources department, the benefits department, the compensation department, the executive level employees, for everyone to have when you're looking at what decision is best for the organization in terms of these changes and in terms of employees, and do we want to reclassify these employees? So many of you know that as part of the Notice of Proposed Rulemaking that the DOL put out last year, that they did ask for comments from employers and employees and industry groups on potential changes to the duties test under the white-collar regulations. And after getting all the comments back, the DOL decided not to make any changes to the duties test. So we know that nothing is changing with respect to the duties test. However, this is a unique time for employers to be able to evaluate the positions within their company and the classification of positions within their company. So what we are recommending to our clients is, in connection with looking at whether to reclassify employees, to also take some time to look at the duties test and see whether the employee should be classified as not exempt because they don't meet the requirements for the duties test as well. It is a rare opportunity to make these corrections because really most likely your organization is going to be implementing some reclassification decisions anyway. So reclassification decisions that are made based on the duties test can sort of fly under the radar with the other classification decisions, reclassification decisions that are made based on the salary level test. It reduces the possibility of triggering litigation. Most employees know that there are changes that were made. So employees being reclassified at this particular period of time will not be surprising to them. So in terms of the duties test and looking at kind of going through a job review process, this process can take some time. First, we recommend that it's important to conduct this type of process under a review of attorney-client privilege. So it's important to consult with your employment counsel and make sure that you are keeping this process privileged. Then we suggest pulling all of the data and information about the job. So it can mean pulling data on salary, bonuses, number of direct reports, and educational degrees out of your HRIS system. Next, review the applicable documents. So some of these documents that talk about the duties and authority of the job could be job descriptions. They also could be performance reviews, especially if part of your performance review process includes the employee themselves completing a self-review. Oftentimes, employee self-reviews are a very good source of knowing what work the employee is actually doing. Most employees take quite a bit of time with their self-reviews and make sure that they're putting their best face forward in terms of their job duties on their self-reviews. That can be a good source of information that comes from the employee themselves. Next, we recommend interviewing managers who are subject matter experts on the job. Most of the time, this could be like your one-up supervisor, or also could be a couple levels up in the organization about what the duties of that particular job are. So in considering whether to, then the final step is really conducting a legal analysis to determine whether the legal duties qualify for an exemption. And a lot of times this is also the piece that you will want to have counsel involved with, assisting you to make sure that you're not missing anything in terms of the applicable law. But we will recommend, when you're looking at whether you should keep the job as exempt or reclassify it as non-exempt based on a duties test, we recommend looking at the, kind of applying a 50% primary duty test, assuming that, that what percentage of their time they're spending performing exempt job duties. ComplianceHR also has an app that will assist employers in this process too. So this is a service that ComplianceHR provides to employers. It is a fee-based service, not like the cost estimator that we just went through that is actually free on the ComplianceHR website. This is actually a fee service, but it is a really great product. I just spent some time with it yesterday, and it is really great. You go through a series of questions about the position and what type of duties the person does. You also say what state the individual works in, because state law issues can also be an issue when looking at whether someone qualifies for an exemption. And after answering all these questions in this online format about the job duties, it will tell you what's the risk of classifying this individual as an exempt employee. So as you can see on the slide, it shows from low to high, and it gives you what the range is. And there's also different reports that will tell you, here's the reason why, here's the report and the reasons underlying this recommendation that, there's a risk, there's not a risk. This tool can be a really good screening mechanism, maybe not to make the final decision about whether a job should continue to be classified as non-exempt based on the duties test, but to use it as a test on an internal level. These are the folks that we are not concerned about. And then there's another set of folks that, okay, maybe we're concerned about whether these folks should be continued to be classified as exempt. And these are the ones that we want to engage outside attorneys to look at and review. And we want to budget for just them reviewing those jobs, because those are the jobs that we feel like we might have the most risk in terms of, maybe misclassifying those employees. So again, this is a really great tool for employers to use. So, okay, so you made the decision. Getting to the reclassification decision and deciding which employees to reclassify can take quite a bit of time and effort on the part of the organization. After the reclassification decision is over, there are quite a bit of consideration in terms of implementing that decision. So the first thing to think about is whether you want to implement or begin a new compensation plan. Employers have a lot of options here for employees that they reclassify from exempt to non-exempt. So the first option is to continue to pay employees their current salary and just pay additional overtime for hours worked over 40. Another option is to try to manage work hours so the employees do not work overtime. So if keeping the hours to under 40 is not consistent with business needs, employers should want to try to minimize, typically most employers will want to minimize the cost of overtime. So in that sense, then you have two options in terms of how you pay employees. So first is to keep the employees on a salary, or you can convert them to an hourly basis using the cost control formula that we just discussed. So non-exempt employees can be paid on a salary basis. They just have to be paid overtime for any hours that they work over 40. So in order to calculate overtime, if you do continue to pay them on a salary, you have a few options. The first option is to divide the salary by 40 and then pay 1.5 times this rate for all hours worked over 40. This is probably the most simple way to do the calculation, and it is compliant in every state. The second option is to divide the salary by actual hours worked each week. This method is compliant with the FLSA, but it's not compliant in California and a few other states. So if you would decide to go this route, we would recommend seeking the advice of counsel if you have individuals working in states that may possibly not allow such calculation for overtime pay for salaried non-exempt employees. The final way to do it is to use the fluctuating work week method. This method can be a little bit complicated to implement, and there are some problems with it being compliant in California and a few other states. It is one of the most cost-effective ways to pay overtime, but there are other requirements that are beyond the scope of what we're talking about today. They would probably be the source of at least another hour-long webinar for us to really talk fully about what those requirements would be. So again, that's something that if you do implement that type of payment method for salaried non-exempt employees, that you consult with counsel on that. The last thing that we've already covered is considering whether reductions in incentive pay could offset the cost of overtime, whether you could just lower what the incentive pay is that the employee actually receives. Now, one thing to note is that if you do continue to pay bonuses or other incentive pay, if you reclassify an employee, you will then owe overtime on the bonus. So overtime will be owed for any hours worked over 40 during the period in which the bonus was earned. So that's something that's important for employers to be aware of, and it's also something to be important that you work with your payroll service provider on making sure that those calculations are done in the right way. So if these folks are reclassified as non-exempt and they receive bonuses or other incentive pay, that they are being paid overtime on their incentive pay as well. The final consideration is whether there needs to be any changes to the benefits, so the employee benefit plan. So some organizations have different benefits for exempt versus non-exempt employees. So some organizations, non-exempt employees, have different vacation accruals, short-term disability plans, profit sharing, and it's important for employees to look at their benefit plans and consider what the impact is of reclassifying an employee to non-exempt under their benefit plan. Littler has worked with some clients that have reclassified large groups of employees who actually they create a middle group for benefits purposes that they call professional non-exempt, and that was so these employees would not lose certain vacation accruals that they had been receiving, certain short-term disability benefits, and certain profit sharing. So obviously this would require changes to the benefits plan, so it's important to take a look at this now. Next, you want to consider whether to review policies and practices that you have. It's important to think about that a lot of employees have never been classified as exempt before, or as non-exempt, so they've never had a punch time clock. So looking at some of these policies that you have in terms of timekeeping, off-clock work, and what those look like. And actually, in our later webinar in September, we're going to talk a little bit more in detail about reviewing policies. I'm not going to go too much into this right now, but you know, this is part of kind of the final considerations. Is like, what policy changes does your organization need to implement? In the same respect, in terms of policies, that's also practice. Earlier, I alluded to timekeeping for employees who are used to being exempt, who are now non-exempt. Sometimes these employees are employees that they don't sit at a desk all day. They might be, you know, folks that have to travel for work. In that sense, what is considered to be work and what working time are they going to be paid for? But the timekeeping aspect of it is, you know, what options can the employer implement in terms of the employee keeping track of their time? There's a lot of really great applications that provide for timekeeping on smartphones. So an app on your smartphone, on the employee smartphone, that allows them to clock in and out and record their working time, those types of things. But anybody who's implemented those types of changes, those changes do take time. So even though we're going to talk about this in more detail later, I think it's important for, as part of the reclassification process, to really keep an eye on what policies and processes may possibly need to be changed as well. Communicating the changes is something that we're going to talk about, and we're actually going to talk about that information in our August webinar. And so I won't go into it in a lot of detail now, but there are considerations in terms of how you want to communicate the reclassification decision to employees who are being reclassified, and also communicating those changes to their managers. We are lucky in that sometimes this is actually an easier communication to make than it can be if an employer undergoes a wage and hour audit and decides to reclassify employees outside of changes to the DOL's regulations. Here, employers have what I would call a good excuse. You know, the reason for reclassifying these employees, if you're doing so, because the government is making us do this. It has nothing to do with the employee's value within the organization, their contribution to the organization, and you know, making those messages clear to employees who are being reclassified, who may possibly view being reclassified as a non-exempt employee as a demotion. So really being clear in the communications that we value you, we're only doing this because the government is making us do this. And the final piece is really training the employees and their managers on, you know, the wage and hour policies, whether those policies have been updated and revised in response to the new rules, and, you know, what the organization wants people to do in terms of timekeeping and what's considered to be working hours, and to make sure everybody's aware of what those policies and practices are. Finally, I want to talk to all of you about a really great tool that Littler Mendelson offers to employers. I learned a lot more about this toolkit yesterday as well, and it is really a fantastic tool for employers to use, and I think it's also a really great tool for a lot of small employers to use when implementing reclassification decisions and really working towards getting into compliance with the new rules. Littler has a product that we call our Exemptions toolkit. And what this toolkit provides is really all the tools that an employer needs to reclassify employees. Littler offers this toolkit for a fixed fee of $4,000. So it's a one-time, very modest fixed fee, and it comes with quite a few resources that employers can use when they are working through this process. So one of the first things that really the backbone of the toolkit is a reclassification work plan. So really it is a detailed explanation of the reclassification process and really outlines and goes through it step by step. And this work plan was provided and developed by our experts here at the firm, to consider everything that employers need to go through when implementing the reclassification process. It is really a tremendous resource in terms of the document. Also within the toolkit is a communications plan template and material. So a guide to communicating the changes to employees and their managers, including talking points and frequently asked questions. There are training webinars and presentations on everything you need to know about the exemption requirements, hours worked, overtime calculations, timekeeping, and payroll best practices. There are template policies and agreements, which is really great because you can look at the template policies and see what policies your organization has in place now and see whether you want to tweak those policies, update certain aspects of them. And these policies are also national and state-specific policies. One of the things that we like to make sure that our clients are aware of is that, we're talking about the FLSA and the Department of Labor, and that's really what our focus has been because they're the ones that implemented the new regulations. But as much as that's happening, it's really important for employers to remember that they still have to be in compliance with state wage and hour laws. So you need to make sure that you are in compliance with the wage and hour laws of the states in which your employees work. So these template policies provide state-specific policies as well. In addition to the policies, there's also wage and hour field guides that provide comprehensive state-by-state guides to wage and hour laws. Really great for employers. If you have employees, say you have employees in Missouri, Arizona, and Kentucky, and you need to check those states, you can pull the state-by-state guides to look at the critical areas that you need to make sure you're in compliance with the wage and hour laws of those particular states. We also include our wage and hour GPS, which are state surveys of different wage and hour topics. They also include substantive analysis of new legislation and new regulations. These are, again, something that you can check your state to see if there's any new legislation going on in terms of the wage and hour laws. I have heard that there are states that now that the DOL has made these changes, but they are now considering their own changes to their wage and hour laws in response to what the DOL has done, and also in response sometimes to what the DOL hasn't done. The DOL didn't change the duties test, and I think some states may be looking at changing the duties test for exemptions. And employers have to be in compliance with federal and state law when it comes to these things. Finally, the toolkit also comes with 4 hours of consulting attorney time from one of our Littler wage and hour experts, which is great because it can provide you with the information and time that you need to answer the questions that may be raised by looking at some of the tools and resources within the toolkit. We also provide, as part of the toolkit, a trial a trial subscription of the Navigator OT application that we talked about earlier, the one where you can look at whether an employee should be reclassified based on their job duties through ComplianceHR. So that's kind of a great little bonus feature. This really is a one-stop shop to deal with the reclassification process for employers. If anyone on the line is interested in looking at a demo of this product, feel free to reach out to me. I think it's a really great product, and I think it's a really great resource for employers who are maybe smaller employers who are looking at these decisions, are looking at these issues and really don't know where to start. This is a really good starting point, and it does give you the resource of having wage and hour experts at your fingertips to talk to when you're looking at implementing these decisions. So if anyone is interested in that, would like to see a demo, feel free to contact me. So I mentioned our future webinars. I think that these webinars, we've been doing, the first two were hour-long webinars. I think these other ones are going to be a little bit shorter because of the smaller nature of the topic. So I think that they're going to be, look for your email in terms of what the length of these are going to be. But our next webinars are on August 3rd. We're going to talk about communications to reclassified employees and their managers. And on September 7th, we're going to talk about final considerations, including timekeeping requirements, policies, ways to control overtime expenses, and those type of things. Thank you for joining us today. I think now, if anybody has any questions, we have some time if anybody wants to log their questions with Erin, and we can try to address those. Or if you would prefer to address questions offline, you can always email me or call me. I think we'll go ahead and do that. Erin, do you know if we have any questions?
Yes, we do. Can you hear me?
Yes.
All right, yes, there is a question that just came in. It says, where do we go to determine state requirements and restrictions?
Many times you can go to the states will have their own DLL page. So the local state version of the Department of Labor will typically have information on resources for employers in terms of state law requirements. An easier way to short circuit that, if you don't want to go out and try to find the resources yourself, is to, an outside employment attorney who has expertise in the area. They should be able to pretty easily provide you with information. But again, as I just mentioned, the state law requirements are really important, and many organizations operate in different states, and state law requirements really are all over the place. And it's important to make sure that you're in compliance with state law as well as federal law, even though we focus primarily on federal law.
All right, and Jennifer, just to clarify, once the presentation's wrapped up, anyone that's attending the webinar today, they can get a copy of the slides from you and your team?
Yes, we will be emailing out the slides to everyone. Hopefully they'll go out this week. I apologize to anyone who was on with us last time. We had a few technical delays last time, but we will be sending those out, hopefully by the end of the week. And if you want a copy sooner than that, feel free to just email me and I can send it directly to you.
All right, a couple more questions. It says, can you clarify paying overtime on bonuses? We pay our non-exempt employees a salary for 40 hours plus overtime. All employees get a discretionary bonus at the end of the year. Is this taxable?
Well, I will leave the tax issue to the accountants because I'm not an accountant and I don't know much about that aspect of it. But I do know that there are certain requirements in terms of if you're providing employees with non-discretionary bonuses, an employer is obligated to pay overtime to non-exempt employees on those bonuses. So typically what it is that you have to provide them overtime for any overtime worked within the period in which the bonus was earned. You know, I actually had an ongoing litigation on this issue for probably about the past 5 years, and these principles are, they're pretty basic in some ways, but in terms of the implementation for employers, it can be kind of difficult. So it is important to consult with counsel that you make sure that you're doing it the right way, so you don't, you know, get in the trap and the problem of maybe having issues down the road in terms of a wage and hour lawsuit. But non-exempt employees, if they're paid certain non-discretionary bonuses and commissions, they have to be paid overtime for hours worked over 40 within the period in which the bonus was earned.
Do the upcoming changes apply to nonprofit organizations as well?
Yes, they do. If you have been on Department of Labor's website, there are specific communications, publications that are geared toward the nonprofit industry. I have spent quite a bit of time with the final rule, which, by the way, is something around 500 pages of text in really small print. And the DOL within the final rule did address comments by certain industries, including nonprofit organizations. And the way that it came down, that it said, you know, we understand that this is difficult. However, it applies equally to nonprofits. I would suggest looking at the DOL website. I think that there's a pretty good, I think it's probably like a 6 or 7 page resource that talks about how the changes are applicable to the nonprofit industry. But I understand that the nonprofit industry there's so many other considerations, because, you know, employers that are in for-profit businesses, if these increases or if these changes require certain increases and increase the cost of payroll to the organization, sometimes they can pass on those costs to their customers. Nonprofit industry can't do that. Nonprofit organizations don't have that same ability. However, that's why what you can do is, if you are converting individuals to an hourly rate if you're reclassifying these individuals, that you do make sure that you can calculate a cost-neutral hourly rate for them. And that is possible, and you just have to make sure that you plan it right and that you calculate it right. And hopefully, in terms of implementing that, you can do it in a way that has not as big of an impact on your organization, little if any, from a cost perspective.
All right. How many attorney hours were included in the $4,000 package?
There are 4 attorney hours included within that package. So it's access to all of the resources, all the written resources, which I have just looked at all of them, and they are really great resources. And then 4 hours of consulting attorney time, which can help you with the reclassification process if you're implementing that within your organization.
All right, we have time for a couple more questions. One, can you go back to highly compensated individuals? So this applies to them as well if they do not make at least $134,000.
Right. So the DOL has a separate rule for highly compensated employees. So the threshold for those employees is increasing from, I think it's at $100,000 a year right now to $134,004. So that is a change to the highly compensated level. You know, one thing you have to watch out for, and this came up in the training that I'm in right now this morning, is that even if those individuals are highly compensated, you still do have to make sure they're being paid that much, that they still are meeting the duties test for the exemptions, so that they're still, you know, a bona fide executive or administrative employee, and they satisfy the requirements of professional, that they're meeting the requirements for those exemptions as well. There are a couple of different jobs that, you know, could possibly be within that highly compensated level that may not fit within the duties test. Some of those can be some technology jobs, some IT jobs. also can be some sales jobs, may not fall within the exemptions in terms of duties. So that's an important thing to look at when looking at those changes.
All right, one last question. Would this apply to a supervisor who is salaried but completes tasks that fall under the blue-collar description of duties?
Well, that is, well, so you have to look at it kind of as a separate issue. So in order for an employee to qualify for an exemption, so the presumption is that all employees should be non-exempt and entitled to overtime unless the employer can meet the specific test for proving that that employee is an exempt employee. So the first test is that they're paid on a salary basis. The second test is the salary level test, which is the one that has been changed for the DOL, which is now going to be $47,476. And the third one is the duties test. And I think that I'm kind of hearing, maybe I'm reading between the lines in the question, is that maybe you're questioning whether that supervisor might be qualified for the exemption based on the duties test. So note that you have to satisfy all three of those tests in order to maintain the exempt status of an employee. So what I would recommend is looking at whether, what that employee really does on a regular basis, and if they do satisfy the duties test for, an executive level employee or administrative employee or professional employee, like making sure that they also fit within those duties tests. And that's something that you can do internally, or you can advise your outside employment counsel about too. They can help you with those type of decisions. But as part of this process, if you have an employee who's a supervisor like that, who may be on the bubble, it's good to look at their duties and see whether they would satisfy the exemption. Because just because an individual is called a supervisor doesn't mean they're doing duties that satisfy one of the exemptions. The title is superfluous. You really have to look at the actual duties and what the person is really doing and how those fit with the requirements of the exemption.
All right, it looks like that wraps up all the questions. I appreciate everyone attending this morning. Thank you to everyone that took the time out of their day. I'm sure this was very beneficial. Please feel free to keep an eye on your emails for our August and September webinars, and I hope everyone has a great rest of your day. I also want to let everybody know that you can find the recording of this webinar on the higher level YouTube page, and it'll be up by the end of the week. Thank you all very much.
Thank you, everyone. Have a good day.